This is Earl White, real estate attorney. This is a video about how to do a deed transfer in New Jersey. One of the most sensitive issues is divorce that one can go through. And if they're transferring property as part of divorce, I can tell you, having done thousands of real estate transactions and many deed transfers, to make sure there are no title issues in the future when you go to sell, when you go to refinance, you want to make sure the deed transfer is an ironclad process. And that is what we are going to discuss in this video. The first step in conducting a deed transfer as part of the divorce process is having a properly drafted marital settlement agreement. You need a marital settlement agreement that specifically outlines what is supposed to happen with the real estate that you are dealing with. Specifically, who is going to get the property if it's a home, who's going to get the marital residence at the conclusion of the divorce or during the divorce, if that is when the process is happening. The reason you need this in writing in the divorce decree is that otherwise you're just going on the good faith of the other spouse that they're going to honor what was discussed verbally or what was discussed in an email. And that is not the way you should go about this. And it should be in writing. Therefore, if you do not have it in writing, improperly drafted, again, that's beyond my scope, but you need a divorce attorney for really help with this. If you do not have the marital settlement agreement properly drafted, if the other party does not comply with the deed transfer in the future, then you're going to have a problem and you're going to have to go back to court to enforce it. And that's going to be difficult to enforce because it was never in writing. First step here is having a properly drafted marital settlement agreement that specifically designates the party that is to get the property and also to give a time frame for when the deed transfer needs to be completed. The second step in conducting a deed transfer during divorce in New Jersey is hiring the real estate attorney. This is very important in matters of divorce. If you want to do a simple deed transfer and skip out on the attorney, I don't recommend it, but I could sort of understand it. Divorce, not so. You need to make sure the deed was properly drafted because it will create problems either as part of the divorce action or in the future when you go to sell the property. When you go to sell, there will be two documents you must sign. One is an affidavit of title, and that affidavit of title needs to state that you are the sole owner now, and that it will have to state your marital status, and then it will have to explain why your spouse no longer has a marital interest in the property. And if you didn't document this properly and do this right in the deed transfer, then you are going to run into a problem with the buyer's title company questioning whether you have clear title or whether your spouse, who might no longer be in the picture, also needs to sign the documents at the closing. So very important, get an attorney for this to either work with your divorce attorney to make sure those documents are drafted properly. Definitely get an attorney at this phase. Is to have the documents drafted, hopefully by the attorney that you retained. Now, just like any other deeds, there are specific formalities that must be followed. You have to have an accurate legal description with lot and block numbers. You must, anytime there's a signor on the deed, you have to type their name in typing beneath the signature. You need to put who prepared the deed at the top of the deed. You need to identify the grantor who is transferring their interest and the grantee who is receiving the interest. And so then also the supplemental forms, the get rep form, which is needed which states that you're a resident, and the reason it says you're a resident, and other applicable provisions that apply to the deed transfer, and an affidavit consideration that identifies what was the consideration on the transfer. In this case, there's probably no for divorce. There's probably no well, you know what? For divorce, sometimes there is finances changing hands as part of the transfer, but typically not. So the consideration, not money changing hands, but the amount of the open mortgage on the property, if there is one. Now, for drafting the deed specifically, it is critical that certain language make it into the deed. I'm going to read from a deed that we did a few months ago, so you have clarity on how the specific wording needs to go. So wife was married to husband on the date and subsequently was divorced from husband on the date of divorce in the Family Division of the Superior Court of Essex County under docket number, list the docket number, then husband is executing this deed to waive and relinquish any marital interest in the property and to waive and relinquish any right of joint possession as a principal matrimonial residence. So you need that language in there to make sure you're covered if it's ever questioned whether that deed resolved a marital interest, which can come up for different reasons. Like I said, you have to give an affidavit when you close, and maybe your spouse stayed at the property, even if maybe you got the deed completed, but your spouse was still at the property after, or maybe the divorce wasn't finalized. If you don't have this language in this deed, the marital interest could still stay open, because the marital interest will, anytime two spouses live together at a property, marital interest attaches. So if you didn't specifically relinquish this in the deed, then that's going to become a problem in the future. Step 4 in the deed transfer process. You need to have this deed recorded within 90 days of the final divorce decree. In New Jersey, there's a cost called the realty transfer fee. That is a cost that is paid to the state. If there's no open mortgage, you don't have to worry about this. But if there is an open mortgage, to avoid paying that realty transfer fee, you have to get it recorded within 90 days. So you do not have to pay this fee. So I'm just reading from the standard New Jersey form affidavit of consideration for the exception. So the fee, full exemption from realty transfer fee, the fee imposed by this act shall not apply to a deed recorded within 90 days following the entry of a divorce dissolution decree which dissolves marriage or civil union partnership between grantor and grantee. So if you want to save yourself thousands of dollars, get this done, get this deed transfer done within 90 days of the divorce completion. The final step in conducting a deed transfer during a divorce is to notarize the documents and have them recorded. In New Jersey, deeds must be notarized either by a notary public or witnessed by an attorney. Then, once you have all of the documents notarized and signed, then you must submit the documents to the county for recording. There are 3 ways to submit the documents to the county to get it recorded. First is e-recording, where you pretty much scan it into the computer and upload for e-recording, which is how this is most commonly done for most deed transfers nowadays. You can also do it via paper mail, mailing the executed documents to the county. We recommend always doing the deed transfers via e-recording so your documents do not get lost in the mail. Even with expedited shipping, documents can still get lost. E-recording is faster, just sign them, scan them, submit them, and then it speeds up the whole process. Once you've submitted the documents properly drafted, then typically under 30 days, most counties will have the documents recorded, and that will conclude the deed transfer process in New Jersey.